Major breaking news out of the United States Supreme Court. The Supreme Court has denied cert in the Wilson versus Hawaii case. This is the Spirit of Aloha case. This is not a particularly big surprise because this was on an interlocutory appeal, but we need to talk about it because there's some powerful statements made, not against the denial of cert, but speaking to issues like licensing, shall issue licensing regimes, and the like. Let's talk about what Clarence Thomas, Neil Gorsuch, and Justice Sam Alito had to say about this denial of cert in Wilson versus Hawaii and what it means for your Second Amendment rights going forward. Stay tuned. Hey folks, I'm Mark Smith, host of the 4-Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee in the 2025 Gundies Awards for Top Voices of 2A. If you have a chance to vote for the Gundies, you can vote every day through the end of the month, I believe. Make sure you vote for Mark Smith 4-Box of Diner in the Top Voices of the 2A for the 2025 Gundies Awards for Las Vegas at the end of January in conjunction with SHOT Show. Always a fun time to be out there. I hope to get out there again this year, and maybe this year we'll take home the prize. I appreciate your support. Okay, folks, so this is a major breaking news story, but it's not anything I want you to worry about, okay? The U.S. Supreme Court has denied cert in the Spirit of Aloha case, which is the case that was decided by the Hawaii Supreme Court. This is its highest state court in Hawaii that basically denied a Second Amendment defense by the criminal defendant, Mr. Wilson. Now, there's a little nuance here, and I don't want you to lose sleep about this case, but I'm going to give you the fundamental thing to take away from this case. Listen carefully, folks, and if you're litigating these cases, listen carefully. Don't F this up again. It is crystal clear that the U.S. Supreme Court has made it crystal clear, including Justice Thomas and Justice Alito and Justice Gorsuch, who are very good on the Second Amendment, of course, that you should not bring interlocutory cases, which means cases in the middle of the process. Don't bring cases to the U.S. Supreme Court seeking cert until you have a final judgment, which means if you have a choice to seek cert on a preliminary injunction or in the middle of your case, don't waste your time, the court's time. You're only delaying time, helping out the anti-gunners. If you're going to lose your Second Amendment related case, then lose fast, preserve your arguments, and lose fast so you can get to the Supreme Court as fast as possible. But if you seek these reviews on an interlocutory basis, it is a waste of time and money and resources. Stop doing it. Don't listen to Mark Smith 4-Box of Diner, even though I've been telling this for about 2 years now. Listen to the U.S. Supreme Court in this decision of Wilson versus Hawaii. Okay. With that message being conveyed, let's turn specifically to this case. Now, this is a little bit of a quirky case. Now, listen carefully to the time. The dates are very important to understand what happened here. In 2017, the criminal defendant, Christopher Wilson, was on private property, walking along, hiking a trail in Hawaii. For whatever the reason was, he was arrested for trespassing, whatever it was, and he was found to possess handguns. But he did not have a license. Now listen carefully. He did not have a license. He had not applied for a license. He did not have a license when he was arrested in 2017. Now why am I hammering home 2017? Because in the year of our Lord 2022, what happened? Nyserba versus Bruin was decided. And Nyserba versus Bruin specifically said, although it was a ruling about the New York may issue permitting regimes, it specifically referenced the Hawaii may issue permitting regimes as one of those handful of states that did not respect the Second Amendment, basically saying that the licensing regime that was in place in 2017 when Christopher Wilson was arrested for unlawful firearms possession without a license, the regime that he would have had to apply to get that license in 2017 was illegal and unconstitutional as already determined by the United States Supreme Court in 2022 in the Bruin case. So here Mr. Wilson is saying, you can't force me to seek a license in 2017 with a regime that was wholly unconstitutional as determined by the U.S. Supreme Court in 2022 in the Bruin case. So the way the Hawaii Supreme Court played games here is they basically decided this entire case based on Hawaii, hear what I'm about to say, on the Hawaiian Constitution, which is where you get the phrase, the Spirit of Aloha, right? The Spirit of Aloha somehow said that under the Second Amendment of Hawaii's state constitution, it doesn't exist because of the Spirit of Aloha. But the Hawaii Supreme Court intentionally then skipped over, claiming that because Mr. Wilson had not applied for a gun permit to carry, he could not really raise that defense. He lacked standing. Now, the Supreme Court here in the Wilson case has basically indicated that that is not a basis for denying Mr. Wilson himself the ability to raise a Second Amendment defense, because the court here, in these statements made by the justices in denying cert, now they denied cert today because it was an interlocutory appeal. That's the reality of it. But they did offer some statements for lower courts about the Second Amendment, which is helpful. And we'll get into those in a couple minutes. But what he specifically said with respect to Mr. Wilson's case, they said, just because you haven't applied for a permit to a system that is wholly unconstitutional, as found by the Bruin case in 2022, that does not mean you cannot assert a Second Amendment defense for failing to carry for carrying a gun without a permit. Because obviously, if he's able to say that the permitting process that existed in Hawaii in 2017 was unconstitutional, he has no duty to apply to it. And if he's caught with a gun without a license, he can say, well, I didn't have to apply because it was unconstitutional. That is the argument that basically the Supreme Court indicated to Mr. Wilson and his lawyers that he needs to really hammer home on to win on the merits of his federal Second Amendment claim. Now, that may not get him out of his trespass claims, but it will likely get him knock out these gun carry charges, because it's crystal clear that he would have applied for a carry permit in 2017 to a regime that was unconstitutional, and therefore he would have been able to get a license if that regime was a constitutionally constructed regime. So I think this is good news, likely for Mr. Wilson's case in and of himself, but I don't think it speaks too much about the Second Amendment, except it reminds us about the interlocutory appeal rule we must follow going forward as a Second Amendment community. But there's some other very powerful statements here from the U.S. Supreme Court, specifically from a statement made by Justice Thomas and Justice Alito. Let's check out some of the things they said. You're going to be very impressed. And Justice Gorsuch also wrote a separate statement that basically sort of rhymed a lot with what Justice Alito and Justice Thomas had to say. Here's what Justice Thomas had to say to start. Justice Thomas writes, quote, "In Nyserpa versus Bruin, we singled out Hawaii's firearms licensing regime as analogous to the New York regime we held unconstitutional. We explained that the states cannot condition an individual's exercise of his Second Amendment rights on a showing of special need. Yet the Hawaii Supreme Court ignored our holding in the decision below. It instead stated that Petitioner Christopher Wilson could not invoke the Hawaii regime's unconstitutionality as a defense in his criminal proceedings because he had never applied for a license. That conclusion contravenes the settled principle that Americans need not engage in empty formalities before they can invoke their constitutional rights, and it wrongly reduces the Second Amendment to a second-class right. Although the interlocutory posture," listen carefully, folks, "although the interlocutory posture of this petition weighs against correcting this error now, I would grant cert in an appropriate case to reaffirm that the Second Amendment warrants the same respect as any other constitutional right." All right, you hear what I just said? Very nuanced language, but crystal clear. Hey, Second Amendment lawyers out there, read this. Clarence Thomas, Justice Alito are literally saying, we don't want interlocutory appeals dealing with the Second Amendment. Now, if it's an immunity case like Pilka, that's separate, because immunity cases are a special category, because the whole premise of an immunity law is to prevent you from having to go through the process itself. So if it's an immunity argument you're raising, that's different. But if it's a straightforward Second Amendment challenge, please listen and read what Justice Thomas and Justice Alito have to say here and act accordingly. Stop wasting client money and time and effort on things that are clearly dead ends. That's all I'm going to say about it. Okay, now let's see what else Justice Thomas says. He goes on to make a very powerful point about this distinction that 2017, the law in Hawaii was no good because of the 2022 Bruin case. Here's what Justice Thomas writes next. In December 2017, police arrested Wilson after he wandered onto private property while hiking. At the time, he was carrying a loaded pistol without a license. The county prosecutor charged him with misdemeanor criminal trespass and firearms offenses. These offenses included charges for carrying guns and ammunition in public without a license. But then Clarence Thomas points out, quote, the result of this scheme, meaning the licensing scheme, was that very few Hawaiians could obtain licenses. In 2017, the year of Mr. Wilson's arrest, Hawaii police granted 0 licenses to private citizens. So there you have it. This is the argument that they basically have sketched out for the lawyer for Mr. Wilson to make to the Hawaiian court system as to why it's game over. They're not going to be able to convict Mr. Wilson on carrying an unlicensed pistol because the only way he could have gotten a license was to go through the unconstitutional illegal scheme of Hawaii's. And this is basically, as I see this, is an attempt by the Supreme Court justices to write the arguments for the lawyer for Mr. Wilson. I'm sure Mr. Wilson has an excellent lawyer, by the way, but this is clearly a signal from the Supreme Court that I don't think will be lost on the Hawaiian courts. But we'll see what happens next. But let's carry on. Let's see what Clarence Thomas has to say about the Hawaiian Supreme Court, because they do not get out of this unscathed. This is what Justice Thomas writes with the support of Justice Alito. The Hawaiian Supreme Court specifically took aim at our focus on original meaning, bemoaning the policy consequences. The Hawaiian Supreme Court asserted that an originalist interpretation of the Second Amendment disables the state's responsibilities to protect public safety, reduce gun violence, and safeguard peaceful public movement by putting firearms restrictions mostly out of bounds. And the court denigrated the need for public carry, in particular, rejecting as un-Hawaiian a federally mandated lifestyle that lets citizens walk around with deadly weapons. On the Hawaii Supreme Court's view, a sounder approach to the constitutional interpretation would give due regard to the spirit of Aloha and would preclude any individual right to bear arms. So basically what you have here is Justice Thomas making fun of the Hawaiian Supreme Court and the justices on there, like, you guys are morons. Read between the lines. Remember, Supreme Court justices are not mean and nasty. They're very polite. They're very civil. For example, when you argue before the Supreme Court, your adversary is referred to as your friend. That's what you say. So when the Supreme Court is making comments using the words like bemoan, and they're talking about the spirit of Aloha, that's a message that you've screwed up, and they don't think you're very good, and they're kind of disrespecting you in a professional, polite, civil way, but it's clearly a message and not a good one to the Hawaiian Supreme Court. And it's well-deserved, by the way, because the Hawaiian Supreme Court is not impressive, shall we say. Well, the next powerful thing that Justice Thomas says, he really emphasizes, and this is a message, I think, to his fellow justices, who I'm sure they get it, that it's very important to make sure the Second Amendment remains a first-class right and doesn't fall into second-class right status. And this is what Justice Thomas, with the support of Justice Alito, had to say about that in the statement today. The decision below is the latest example of a lower court failing to afford the Second Amendment the respect due an enumerated constitutional right. As this court has repeatedly emphasized, the constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. So the Hawaii Supreme Court cannot single out the Second Amendment for disfavor, even if it does not believe that the right is really worth insisting upon. Again, another message to the Hawaii Supreme Court to get your act together. You may not like it, but you got to follow the Constitution. When Hawaii became a state, you agreed to follow the United States Constitution. Do it, and do it now. Message to Hawaiian Supreme Court and the Hawaiian court system from the Supreme Court itself. And the last thing that Justice Thomas said that I think is worth noting is he really does remind, again, everyone the importance of these carrying cases. And this is quite interesting for those of you who are looking into the licensing issue, whether it be shall issue licensing, permitless carry. This language here is quite significant because it talks about, whether or not these regimes are constitutional or should they be constitutional, and whether the Supreme Court needs to take another case to deal with it. Here's what Justice Thomas and Alito write next. In an appropriate case, however, we, the Supreme Court, should make clear that Americans are always free to invoke the Second Amendment as a defense against unconstitutional firearms licensing schemes. Perhaps Wilson himself will present that case should he file a post-trial petition for cert. Regardless, this issue is an important and recurring one. And this court, meaning this Supreme Court's This court's intervention clearly remains imperative, given lower courts' continued insistence on treating the Second Amendment right so cavalierly. Powerful language from Justice Thomas. Now, there was also a separate statement or opinion by Justice Gorsuch, although he agreed that you shouldn't take the case on an interlocutory basis, which we've gone over already. He does go on to specifically say, he conveys another message to the Hawaiian Supreme Court that they better get their act together when it comes to the Second Amendment. Here's what Justice Gorsuch writes in a separate statement about the importance of these licensing issues and what the Hawaiian Supreme Court should do to fix it. Here's what he writes. I do not mean to suggest Mr. Wilson's Second Amendment defense has merit. I observe only that no one knows the answer to that question because the Hawaii Supreme Court failed to address it. Hint, hint, Hawaii Supreme Court. And that failure invites with it the distinct possibility that Mr. Wilson may be convicted of and ordered to serve time in prison for violating an unconstitutional law. Hint, hint, Hawaii Supreme Court. He goes on to say, and often courts revisit and supplement interlocutory rulings later in the course of proceedings. Perhaps the Hawaii Supreme Court will take advantage of that opportunity in this case. If not, Mr. Wilson remains free to seek this court's review after final judgment. Justice Gorsuch is telling the Hawaii Supreme Court and the court system, do the right thing, follow the law, don't mess this up again. So again, it's a subtle message. We'll see where this goes, but here's my prediction. In the next year or so, whenever this is resolved by Mr. Wilson, I suspect the Supreme Court or someone in Hawaii is going to find a way to make sure that Mr. Wilson is not convicted of these gun-related charges. Because if he is convicted of these gun-related charges, I suspect there will be a very bad outcome for the Hawaii Supreme Court before the U.S. Supreme Court, given this language here and right now. But the bottom line is the Spirit of Aloha case has been denied cert, which is what we predicted. This is not newsworthy beyond the statements made of the justices and the lessons that we all can glean moving forward. But with that said, the big kahuna, if you will, is the Snope case that we will have an answer on in the next 5 weeks. Okay, folks, there you have it. Hope you learned something here today at the 4 Box Dinner. Make sure you vote for me for the Gundies 2025 Top Voices of 2A. Don't forget to follow this channel and subscribe and to share it with your friends and follow me on X at 4 Boxes Diner. We now have well over 20,000 followers over on X and we're growing. We're still new there, but we're growing it. And I look forward to talking to you all again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.